we'll also see the report of the amicus. We will hear whatever objections say CRIDAI has, and in the meantime, you take instructions for the state of Maharashtra. And if something remains, we will deal with it and otherwise resolve it. Because now we'll take that on the record. Prima facie, we should take these agreements on the record and say that all states will have to implement this, because there has to be some uniformity otherwise.
My lord, as far as Nagaland is concerned,
Nagaland, they are looking into it. They are in touch with the chief secretary, they said.
in fact, we want to refer the matter in terms of the constitution to a committee
Well, let's on instructions.
constituted by the Legislative Assembly of Nagaland, specifically
You want to withdraw
for
also?
looking into whether the laws are in consonance with Article 371.
Otherwise, let's say you'll have the stigma of
Nagaland
dismissal.
specific issue, we can keep aside a little bit.
Anyway,
Because, we need not allow the Nagaland issue to sort of, because this is vital for the entire country. Otherwise, otherwise,
Because
buyers
last time
all
on
over the
14th
country
of
are being
August when the
defrauded
matter
by
came up,
dealers. Now, if we have one
Your
model
Lordship
agreement,
asked me to give
at least
three
there
names
is
of
there is
retired
some
judges.
guarantee
So
that,
I gave three
there
names.
is some
One was
uniformity
Justice
in
K.L.
what dealers impose on buyers.
Justice Davre, and
Nagaland, I quite
Justice
see this is the Article 371A issue. We'll keep it slightly out of the picture for the present. And you also take instructions on what is the way forward insofar as Nagaland is
Meeting
concerned.
is happening today. RERA itself applicability. So when it becomes applicable.
The basic thing, Mala, we are constructing. First thing, we should be in the document, Mala. What will the strength, like strength of the foundation?
That's all right. Therefore, now the model agreement covers these aspects.
No, Mala, so it is.
My lords, there is a schedule D which says specifications, amenities, etc.
Okay.
It's my understanding that is where it should fall. It cannot really be otherwise.
It has to be in specifications.
Yes, Mala.
The
Otherwise,
specifications.
We'll keep it on Thursday. We'll hear you for 5
depends on
minutes.
the column status is M20 or M25, M30. Mala, it's
All right. We'll look at it then.
My lords, may I just make a request? The Lordship may consider kindly have it on next Wednesday. Thursday, I'm somewhere.
Not this Thursday. All right. Monday?
Next Monday.
Monday or
Wednesday.
Friday?
Actually, there's a family marriage, so that's why
Keep it next Friday then.
I'm so grateful.
We'll keep it Friday week then. Friday week. Mr. Bharuka, just make sure that it is the report which has been prepared. The report which has been prepared by Mr. Devashri Bharuka, Learned Senior Counsel, in consultation with the Ministry of Housing and Urban Development. The Union Ministry of Housing and Urban Development has not been scanned and prepared and placed in the record. The registry shall ensure that this is done by the next date of listing. Full stop. If any counsel appearing in the matter who desires digital copies of the report of the amicus curiae shall be at liberty to obtain copies from the registry. List on, we'll keep it Friday week so that we can dispose it of.
I was able to actually download this from the e-filing website, so probably it's there available on the.
It's there, but somehow it's not being provided to us. All right.
my lord, may mention also as far as state of Nagaland is concerned, it can be taken up.
Today the meeting is being held, so that we are not saying anything about Nagaland for the reason that Ms. Bhatti said today a meeting is being held.
No, I am conscious of it. I am a member of that committee of the
Tell us next time. We are not passing any order for implementation today. So there's no order for implementation by any state or UT today. So let's apprise us on the next date what happens about the state of Nagaland.
Grateful.
The item 23 also, there is an error on our part. We have not filed that affidavit, my lords. That affidavit, we assumed it was filed. It's notarized in February. The accessibility guidelines have been framed after the committee was constituted. We reported, your lordships may consider having it next week.
All right.
We'll see that it's filed, my lords.
This was only viewed. Wait and
Yes.
we'll keep it next week.
Please, my lords. Grateful, my lord.
Service complete.
Claim is about US dollars 2 lakhs, 200,000 US dollars.
Yes, ma'am.
Which claim?
And on our part, we suggested one arbitrary, my lord, at page 71. This is in Kerala, my lord, Tiruvalla. That is agreed, my lord. That is page 46. Page 46 is an agreement clause.
is Chairman AFT still, or that term is expired?
I'm sorry, madam? This arbitrator, he's based in UK, Lord, London.
No, we'll have an arbitrator here.
We have suggested, I am only bringing notice, Lordship, but we have suggested that page 71, in that arbitration notice, we suggested name of one arbitrator. Lord. I leave it to Lordship.
The service is complete. Bearing in mind the arbitration agreement between the parties, Mr. Devashish Baruka, Learned Senior Counsel, is appointed as sole arbitrator for the Arbitration and Conciliation Act 1996. So the petition is accordingly disposed of. These international arbitration.
So happy for the respondent. In fact, this matter has been settled. The company has issued a notice certificate to us on 25th of May.
Matter has been settled. The dispute between the parties
Wish to withdraw it.
has been settled. Learned Counsel appearing on behalf of the petitioner therefore seeks permission to withdraw the petition. Petition is dismissed as withdrawn.
So great. Grateful.
The petitioner.
I have instructions to state that we want to settle this matter. If the matter may be referred to mediation.
We'll appoint an arbitrator now and you can settle it in arbitration.
There are 10 then I have
Both
objection.
parties have submitted to arbitration. They've appointed their arbitrator after the petition has been filed. There in
This
the reply.
matter, Malins, the notice invoking arbitration itself is not on record, Malins. They say that arbitration was invoked on 8th March 2022. That notice itself is not there, Malins. That's number one, Malins. Number two is, Malins, kindly see their prayer. Because the prayer is at page number 16.
To appoint Mr. So-and-so District Judge, Judicial Member, NCLT.
Malins, that is their own nominee, Malins.
We are not going to allow that prayer. We'll appoint an arbitrator.
My submission is, that can be referred to mediation. We'll first try to attend for mediation.
We'll refer it to arbitration, and then you can negotiate between yourselves, try and see if there's some resolution possible. Instead of keeping it pending, we'll dispose it off. How much is the claim actually?
$303,000.
How much does that work out to about approximately?
About 2.5 crores.
It's a tribunal for 3 members.
It's a 3-member tribunal.
They have already appointed. They have already.
Instead of 3 members,
As per the clause.
why don't we have one arbitrator, a sole arbitrator?
Yes.
By consent of parties, we may appoint a sole arbitrator. Because 2.5 crores, appointing 3 arbitrators, the entire amount will go in the fees of the arbitrator,
Absolutely correct.
right?
My lords, with respect, both parties have submitted to the 3-member tribunal. Both parties have appointed their arbitrators as well.
You want 3-member tribunal?
I don't have
2.5
for single member.
2.5 crores is the amount. If we appoint 3 arbitrators, the arbitrators will consume the entire amount of claim.
Malins, may kindly consider one more aspect.
Bearing in mind the amount, bearing in mind the fact that bearing in mind the amount of the claim, parties have agreed to the appointment of a sole arbitrator to resolve all the claims and differences between them. Full stop. Accordingly, acceding to the request of the Learned Counsel on behalf of the contesting parties, Mr. Nakul Diwan, Learned Senior Counsel, shall stand appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. The sole arbitrator may fix his fees in consultation with the parties.
Submission may be recorded that parties are willing to settle and they may explore mediation.
Since parties are willing to explore the possibility of a mediated settlement, it would be open to them to approach the mediation center of the Supreme Court in the meantime to explore whether a settlement is possible.
Much of this submission. If the mediation could be in Hyderabad, in the High Court.
We'll do it here now.
Yes.
Resume appointment.
Any district judge in Delhi, because the size is
How much is the claim?
38 lakhs.
38 lakhs or crores?
38.72 lakh.
No. That's, so whom should we appoint? You tell us?
Any retired
May I
district
request,
judge.
my lord, may I suggest, my lord, instead of going for the arbitration, may I suggest, matter may be referred for the mediation, not my instructions.
Like this previous matter, we'll appoint an arbitrator. In the meantime, you go to mediation. Now tell us who should be appointed as an arbitrator?
In our letter, we have suggested one Justice Arun Arya at page 35, my listeners, retired judge.
Go ahead. Nariman को करना है क्या? The nature of the dispute between the parties, Miss Nina Nariman, Learned Counsel, is appointed as a sole arbitrator. 38 lakhs, we'll go send it to a junior counsel. Is appointed as an arbitrator under the Arbitration and Conciliation Act 1996. The arbitrator is requested to fix her fees in consultation with the parties. The arbitration petition is disposed of. Learned Counsel have also stated, the Learned Counsel for the contesting parties are agreed that in the meantime, they would approach the mediation center of the Supreme Court to explore the possibility for mediated settlement. Full stop. If this is not achieved within a period of on or before 31 August 2024, the arbitrator may proceed with the arbitral proceedings.
May I please, Rashab, this is an application for appointment of sole arbitrator. The service is complete in the matter.
How much is the claim?
Reflects that.
229, 2 crores 29.
The dues are approx 2 crores 14 lakhs 72,000.
We have got a list of arbitrators of the Delhi International Arbitration Center.
And
Small arbitration claim, will you do it as a matter of, you can fix your fees, but we'll refer it to you. Mr. R.S. Chima, former judge of the High Court of Judicature at Bombay. Check kar lo, haan, zara.
obligations.
29, please move.
What has happened to this? This is the provision of sanitary pads for girls in.
Yes, my lord. And 6 November, my lord, 2023, my lord, passed the order.
I remember that. Yes.
Yes.
Lordship had passed these directions, additional directions for the union government to consider before finalizing the
You are appearing
policy.
for the union government?
I am appearing for the union.
Yes. Now what has happened there?
Your Lordship, we have written to the states and in compliance of your Lordship's directions, we have sought all information. However, there is some information which is deficient and the policy is almost ready, but we need additional time to collect the rectified data on the ratio.
So how long do you want? How long do you want?
About 8 weeks, Your Lordship.
Ms. Bhatti, what is the position? Your learned junior says that the data has been collected, but there is some further work to be done.
Yes, my lords, the national policy is taking a little time, my lords. On others, we filed an affidavit, my lords, may consider having everything together, my lords. kindly consider giving us 2 more months, my lords.
So today we are now at beginning of July.
Please.
So should we keep it early September,
I
31st
will
of?
be grateful, my lords.
Ms. Aishwarya Bhati.
In fact, my lord, some of the state like Punjab and other state is doing well, my lord. So kindly look at that policy also.
Ms. Aishwarya Bhati, learned ASG, states that a national policy on the provision of menstrual on hygiene products to school-going
Adolescent girls. my lords.
Adolescent.
for adolescent girls in schools, just adolescent girls,
Please, my lords.
is under consideration, is at an advanced stage of consideration by the Union Ministry of Women and Child Development. Full stop. Learned AG states that a consolidated policy will be prepared shortly and be placed on the record of this court within 2 months. We accordingly list these proceedings on. We'll keep it on a particular date on a Monday in the first week of September.
Very grateful, my lords.
My lord, regarding the toilet also, my lord, girls
We
toilet.
have filed an affidavit on the ratio, but Lordship may consider everything together.
Together we-
My lord said, consider all this in the policy itself.
All right.
Grateful.
Item 30.
Please, Lord.
Seeking a point. Arbitrator.
Now, what is to be done here?
Because in this matter, I beg to appear on behalf of the respondent. Because I am aware of the remit of 11. This is a peculiar case, where Miss Elizabeth Kerker was suffering from dementia and thereafter by Alzheimer's. This is what we have said is she was of unsound mind and was not capable of contracting at all. The Vidya Trollia principle, where lordships have sort
That's
of
a matter for the
distinguished
arbitrate.
between section 11-12 of the Contract Act as opposed to the contracts which are voidable. That's my really defense. And
That's a matter to be argued.
but here, my lord, would be a case where she's of unsound mind.
Whether she was of unsound
My lord,
mind.
that will be, of course, subject to medical records, which we have placed on record. I'm also handicapped because the residence where she used to stay, has been taken over by Yes Bank. I am not even able to access my house, her belongings, etc. So I am communicating with Yes Bank to at least permit me inspection.
Who are now you are the legal heirs.
Yeah, I'm the legal heir. I appear on behalf of her husband and her 2 children, Ajit and Urshila.
We'll appoint an arbitrator. You can ask, having regard to the claim, we'll not appoint a former judge or something. We're appointing members of our own court, of our own bar, as arbitrators in these smaller.
I don't know, the claim may be.
Claim is around 4.5 crores in
4.5 crores.
in 19. So around 5.5 today.
So my contention may be recorded.
Yeah, that's really
So that she's of unsound mind. Because otherwise, you make carve out that distinction.
bearing in mind the presence of the arbitration, the existence of an arbitration agreement, this court in the exercise of its jurisdiction under Section 11 of the Arbitration Act 1996 would have to appoint an arbitrator. Would stop. The defense of the respondents, who are the heirs of Miss Elizabeth Kerker, that she was not in full possession of her faculties when she signed the agreement, is a matter which will have to be decided by the arbitral tribunal. Full stop. We accordingly appoint Mr. Shadan Farasat, learned counsel practicing before counsel, as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. The arbitrator may fix his fees in consultation with the parties. The arbitration petition is disposed.
May I request that issue be treated as a preliminary issue, because
that we can argue there.
All right. Obliged.
May I mention a fresh matter in item 31, my lord. Members, I have mentioned, this is a petition filed by 56 students from Gujarat. We are opposing any prayer for cancellation for the reason that the preconditions, so it may be tagged, my lord. I have the diary number. Will not be take
Just keep the diary number, give it to the court master.
We'll issue notice. My lord.
All right, now we are nearing 1. Now tell us broadly, we'll come back after lunch. Now just tell us broadly, we can't hear all counsel here. We'll have to hear representative counsel.
Item 1, which is the original item which this honorable court was pleased to issue notice that writ petition was entertained. At that stage, my lord, because the facts were not very clear, so this honorable court refrained from passing an interim order. If I can just sum up the matter, my lord, in my...
Now, which is the first? Are you on the first in the group of neat matters?
That's fine. Item 31.
I said,
Item 31.
31, 1 is mine. 31, 1 is mine. Second case is mine.
31.9 is mine, sir.
I am in 31.4 and I have filed an application for withdrawal of my writ petition.
The NTA has filed reply.
Let's, in 5 of the cases,
I